So you took a 6'2" serial rapist, serial child rapist with male genitalia, and he said, you know, I'd like to be in a women's prison. And your answer was, that sounds great to me. Let me ask you something. The other women in that prison, do they have any rights? The Bureau of Prison argued what I'm saying right now, that if you put this person in a female prison, there will be a risk of sexual assault to the women. And you know what you did? You said you didn't care about the women. In what universe is someone who is a serial repeat child rapist not at a risk of reoffending? And it is clear on your record, your political ideology matters a heck of a lot more than the rights of those women that you endangered. I think you're a radical, and I think you have no business being a judge.
Thank you, Judge Netburn. Senator Padilla.
That's directly contrary to what your report
you all have
said.
had
No.
We're going to be.
You're going to follow up, and that's how it works.
There is not.
That is exactly how it works.
Look,
if you follow up, you didn't get extra time, and she just directly contradicted her own report. I'm just going to read her own words because it's exactly the opposite of what she said. Your own report.
Senators,
So does every Democrat senator want to cover up the facts here? Is any Democrat
So can we
interested
return
in the direct
to Senator? We'll be returning to Senator
Apparently,
Padilla's questioning, or we will adjourn today's hearing.
You want to adjourn? Go ahead. You can do that.
Go ahead. Senator Padilla, I want to give you your 30 seconds.
You might as well, because the
Padilla,
questions are going to be, are you more handsome or beautiful or brilliant? And let's avoid the facts. Well, Judge Netburn, I'm going to continue on this line of questioning. In your court, what matters more? The rights of individuals or your political ideology?
I apply the law to the facts.
I asked a question. Which matters more?
Well, my political ideology doesn't matter at all.
Okay, so I don't believe you. And I think this case demonstrates that you are willing to subjugate the rights of individuals to satisfy your political ideology. This case involves a male defendant who raped a 9-year-old boy. Was he guilty of that?
Yes, the petitioner pled guilty to that.
Okay, so he raped a 9-year-old boy. He also raped a 17-year-old girl. Was he guilty of that?
He pled guilty. The petitioner pled guilty to that crime as well.
So was he guilty?
I hope so, because she pled guilty to it.
He was a he when he did this.
That's correct.
And also criminal deviant conduct, which the record doesn't disclose what that was exactly. Then, after serving in prison, Mr. McClain was released for parole, but then violated the terms of parole by having internet and was sent back to prison. 1 year after being released again, he was convicted of having child pornography. Is that correct?
I'm unclear on exactly the time frame that you're at, but the petitioner was convicted of distributing child pornography.
Child pornography that was images of adults violently raping children.
Abhorrent conduct.
Okay.
For which there are real victims.
And this individual, 6'2", biologically a man. A minute ago you said that when this man decided that he was a she, you said this individual was, quote, I wrote it down, sober and entirely a female. That phrase struck me as remarkable. Did this individual have male genitalia?
I think what I said, or at least what
that is a verbatim quote, entirely a female.
Sorry, what I meant to say was hormonally a female.
Okay, but that's not entirely. Did this individual have male genitalia?
Yes.
So you took a 6'2" serial rapist, serial child rapist with male genitalia, and he said, you know, I'd like to be in a women's prison. And your answer was, that sounds great to me. Let me ask you something. The other women in that prison, do they have any rights?
Is that a question you're asking me?
Yes, the other women in that prison, do they have any rights?
Of course.
Do they have the right not to have a 6'2" man who is a repeat serial rapist put in as their cellmate?
Senator Cruz, I considered the facts presented to me, and I reached a decision based on what the law is.
I asked you a question. Do they have a right not to have a 6'2" man who is a serial rapist put in as their cellmate? Do those women have a right to that?
Every person who's incarcerated has the right to be safe in their space.
But you didn't think so. You didn't think so. And in fact, I'm going to give some quotes from your order because Senator Kennedy is right. This is not a judge's order. This is a political activist. By the way, the beginning of your order says, at birth, people are typically assigned a gender. I got to say that would astonish a lot of Americans. A lot of Americans think you go to the hospital, a baby is born, and congratulations, you have a little boy, a little girl. The assigned a gender, I know you went to Brown, but it sounds like it's in a college faculty lounge with no bearing on reality. The Bureau of Prison argued what I'm saying right now, that if you put this person in a female prison, there will be a risk of sexual assault to the women. And you know what you did? You said you didn't care about the women. I'm going to quote what you wrote. You wrote, quote, "The Bureau of Prisons claim penological interest in protecting female prisoners from sexual violence and trauma. This interest is legitimate," that's kind of you to say, "but there are no signs that petitioner is at risk of reoffending. The record is devoid of evidence of incidents of violence or assault during petitioner's incarceration when she was the perpetrator, only the victim. A theoretical risk of sexual assault by the prisoner without more cannot support the BOP's position. No evidence, theoretical." Have you dealt, in what universe is someone who is a serial repeat child rapist not at a risk of reoffending?
Senator, as I do in every case.
Okay, I know you've been told to repeat the line, "I follow the law." I asked a question. In what universe is someone who is a serial repeat child rapist not at risk of reoffending?
Sir, I looked at the facts that were before me in this case. All of the evidence, including the statements of every warden who had supervised this petitioner.
You also wrote, "The BOP also posits that permitting petitioner to live among women will be traumatizing and possibly dangerous to them. This concern is overblown." I have to say, if I were the father of one of those women, and you decided that my daughter's cellmate was going to be a 6'2" man who over and over and over again committed violent sexual assault, I would say the entire justice system is absurd, and it is clear on your record your political ideology matters a heck of a lot more than the rights of those women that you endangered. I think you're a radical, and I think you have no business being a judge.
Judge Netburn, there was an opportunity during your exchange with Senator Cruz that you were attempting to offer a response relative to the conditions under which this petitioner was unsafe in the facilities in which she was being held. I'd like to offer you the opportunity to finish that response.
So the facts that were presented to me and what I relied on to make my decision were that the petitioner had engaged in no violence, no physical violence, no acts of sexual violence whatsoever while in custody. All three wardens who supervised the petitioner requested that she be transferred to a women's facility because of her serious medical needs. In addition, the Bureau of Prisons' longtime medical provider testified at a 2-day hearing in my courtroom and recommended that the petitioner be transferred because of her serious medical needs. And the last thing I'll say is that the Transgender Executive Council, which is the body that makes decisions on behalf of transgender transfer requests within the Bureau of Prisons, never said that the petitioner could not be transferred, and never, ever said that she couldn't be transferred because of any risk of violence. What the Transgender Executive Council repeatedly said in denying the request was simply that she needed to maintain her hormone levels. That was the repeated justification for the denial of transfer. But the petitioner had reached full female hormone levels before even being incarcerated. At the time, the district judge in Indiana who sentenced the petitioner requested that she be placed in a women's facility. Her hormones were entirely female at that point, and so the decision by the Transgender Executive Council to deny the transfer request based on this idea that it was only because her hormones needed to be consistent and stabilized, I found was a pretext, but they never once said she cannot be transferred because of violence. It was always based on this idea that her hormones had to be.
Thank you,
Madam
Judge Netburn.
Chair.
Senator
Judge
Padilla.
Netburn, that's
Senator
directly
Padilla.
contrary to what your
Senator, you
report
all
said.
have
That is
had
direct-
all.
No,
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 no, no,
no, no,
no,
you're
no,
gonna follow
no,
up.
no.
We're gonna be-
No,
You're
there
gonna
is
follow up,
no
and that's how it
follow-up.
works.
There is
You
not.
allowed
That is
the witness-
exactly how it works.
Look,
If
we're
you
gonna be
follow
allowed
up,
to
you didn't get
ask
extra time,
questions?
and she just directly contradicted her own report. I'm just going to read her own words
Now, this isn't
because
fair,
it's
Madam
exactly
Chair.
the opposite of what she said. Your own
Chair.
report.
Senators,
says, quote,
I gave both of you more time
You-
to finish your
you
line
allowed
of
the witness to
questioning.
testify
I
and
allowed the
introduce
witness
facts.
to
You jumped in
finish
and took
her.
another round.
I allowed
You
the
took
witness
another
to
round.
finish
You
her
opened the door.
response.
You
I
opened the
allowed
door
the
to this.
witness to finish
You're
her
abusing
response.
your status
That is.
chair.
Okay, I understand
That
that you're
is not-
scared of the
You are
facts.
abusing
I
your
have-
status
Chair.
as chair.
Senator
Madam Chair,
Padilla?
You
Madam
can't
Chair,
just open
Thank you,
up
Madam Chair.
testimony
she
and then not
has an
give us a
obligation to
chance
explain
cross-examine.
why she directly contradicted what she wrote in her report. She says in her report, the Bureau of Prisons' claimed penological interest is in protecting female prisoners from sexual violence and trauma. She just told you the Bureau of Prisons didn't say there was a concern about sexual violence and trauma. Those are directly contradictory, and why are you contradicting what you wrote in your report?
And what are
Thank
you
Madam
trying to
Chair.
hide,
I believe
Madam
I
Senator
have
Padilla.
the floor.
No, wait, point of
I
order.
believe
Senator
I
Padilla.
have the floor.
Senator
What are you trying to
Padilla.
hide,
Are you going to
Madam
let her
Chair?
answer that question?
Senator
or you
Padilla.
don't want her to answer that question?
Senator
You're
Padilla.
afraid?
This
Very
is
much,
a
Madam
cover-up,
Chair.
Madam
Senator
Chair.
Are you
Padilla.
afraid of the answer to
This
that
is
Colleague.
no
Cover-up.
Are you
Senator
afraid
Padilla.
of the answer to that question?
Senator
Colleagues,
Padilla.
So yes,
My
you are
time.
afraid of the answer to that question.
Senator Padilla.
Please hold
Clearly,
my
you're
time.
afraid of the answer to that question.
This is
Thank you.
absurd. Madam Chair,
Ms. Newman.
Thank you.
I have a point of order, Madam Chair.
Yes, Senator Kennedy.
Madam Chair, with respect, you allowed the witness to go at length and to change her testimony without her being subject to cross-examination. Are you going to allow us to have a second round of questioning?
No, Senator Kennedy.
What are you trying to cover up here?
There is no cover-up, and Mr. Padilla, Senator Padilla, you'll be allowed the 30 seconds
Well,
remaining
I
left
want
of your
to
time.
appeal the ruling of the
Thank
chair.
you. I'd like to hear the
I would like to
responses
appeal.
from the two
Madam
witnesses
Chair, I have a
remaining.
point of order. I'd like to appeal the ruling of the chair. You allowed a
Your
witness-
point of order was offered and responded to,
and I appeal
and
the
I,
ruling of the chair and call for a roll call vote. You allowed a witness, let me state my case.
Sure.
With respect. You allowed a witness to go on for 4 or 5 minutes, change her testimony, knowing full well that neither Senator Cruz nor I could cross-examine her about her perjury.
Senator Kennedy, would you allow the witnesses
I'm
to finish
still in
responding
the
to my
middle of a
question,
point of
and
order,
then we can
Mr.
act
Madam
on
Chair.
your request?
And I think we
Senator
should
Kennedy.
have a second round.
Senator Kennedy.
And I am appealing the ruling of the chair.
Senator
Senator-
Kennedy, would you allow the witnesses to finish responding to my question, and
And
then we
I
can
am
respond to your
appealing
request?
the ruling of the chair.
Senator Kennedy, I gave you a response to your request of a second round of questioning. I have no intention on allowing a second round of questioning.
And I'm
There
appealing
is-
your ruling.
That is fine. There is no procedure that allows
I
for
would
a
ask for a
roll
roll
call.
call
There
vote.
is no procedure for it that allows for a roll call vote in this committee. This is a hearing. I have the gavel. I have
this is
responded
the
to
cover-up,
your
Madam Chair.
request.
This is an
and I am
embarrassing
going to
cover-up.
return
I will
to
say I've
Senator
never seen
Kennedy's.
a chair try so hard to protect a witness and avoid answering why she just lied on the stand with her own words, her own opinion.
Thank you so much for your request. It has been heard, responded to. Senator Padilla,
not- but
your...
There will be no cross-examination.
If I would like-
The witness shall be
But I
allowed
want
to
to be
lie,
sure I
and no one will ask.
understand your
So,
ruling. I think I have the
There,
floor.
you
Your
have,
ruling
you have
is-
been,
your
you
ruling
have,
is-
you asked for, was there going to be
Well, I'm
another
raising
round
the
of
second
questions?
point of order. Your
The answer
ruling
is no.
that we can't have a second round, that the chair can allow a witness, after we're finished with cross-examination, go on at length, change her testimony, potentially perjure herself. We're not allowed to cross-examine in a second round of questioning, which we do all the time.
The answer is
And
no,
you tell
Senator
me
Kennedy.
I can't, and you now ask for a roll call vote to appeal your ruling.
Madam
and you
Chair.
say I can't do that.
No, you cannot.
That's
Madam Chair,
ridiculous.
point of
Thank
personal
you.
privilege, please. Madam Chair, point of order.
Senator Hirona.
You know, we have been witness to literally witness badgering and now badgering of the chair. She has issued her ruling. There is no appeal. Some of us would like to get on with this hearing.
I'm sure you
and
would.
To have to sit here and listen to all of you go off time and time and time again. And I just want to commend this witness, this nominee, for her comportment, because what her comportment says to me is that she is going to be a damn good judge. Can we get on with it, Madam Chair?
So does every Democrat senator want to cover up the facts here? Is any Democrat
So can we
senator interested
return
in the direct
to
contradiction
Senator,
from
we'll
the
be
witness?
returning to Senator
Apparently, it's
Padilla's
the entire
questioning, or
Democrat
we will
senators that want to
adjourn
cover these up.
today's
You want
hearing.
to adjourn? Go ahead. You can do that.
Go ahead.
Senator Padilla, I
We
want
might
to
as
give you
well.
your 30
You
seconds.
might
the
as
way you're
well,
gonna run the
because the
hearing.
Padilla, I
questions
wanna
are
give
going
you
to
your
be,
30
are you
seconds
more
if you
handsome or
wish. You can
beautiful
yield
or
your
brilliant?
time and we
And
can
let's
allow
avoid the
everybody
facts.
Senator Cruz.
Thank you, Mr. Chairman. I have deep concerns about Judge Sarah Netburn's nomination, and specifically about her radical rulings that endanger women by placing biological men in women's prisons. And given the avalanche of letters this committee has received from women's groups and female inmates, I'm not the only person with concerns. In the case of JJS versus W.S. Plyler, the prisoner, dubbed July Justine Shelby, his real name is William McLean, was a serial rapist. There's no other way to say it. He was also a 6'2", fully intact biological man. His past criminal offenses included child molestation of a 9-year-old boy, rape of a 17-year-old girl, and criminal deviant conduct. No factual details are in the record, but the state defined the offense as, quote, compelling with force or the threat of force sexual conduct. As a result of these offenses, Shelby was incarcerated for 18 years. 1 year after being released on parole, Shelby broke parole by circulating violent child pornography. And so back in prison. And at 51 years of age, Shelby decided that he was a woman. And as a self-declared woman, he demanded to be jailed with biological woman. And failing to lock him up with other women, he argued, was a violation of the Eighth Amendment. Now, luckily for Shelby, his lawsuit ended up in front of Judge Netburn. Putting political ideology over justice and reality, Magistrate Judge Netburn recommended that Shelby, quote, be transferred immediately to a woman's facility. Despite a lifelong pattern of rape, sexual assault, and obvious sexually predatory instincts, Magistrate Judge Netburn's opinion declared that, quote, there are no signs that petitioner is at risk of reoffending. That defies words. Magistrate Judge Netburn doubled down on her commitment to a radical political ideology in her opinion. Casting aside any concerns for the female prisoners, Judge Netburn wrote, the BOP also posits that permitting petitioner to live among women will be traumatizing and possibly dangerous to them. This concern is overblown. Those are her words. Netburn's opinion went on, quote, the BOP's repeated refusal to transfer petitioner to a woman's facility to further her gender transition, despite knowing the condition of petitioner's physical and mental health, violates the petitioner's Eighth Amendment rights. This judge's ruling, the Constitution requires that biological men who wake up one day and say, I'm a woman, have to be housed with female prisoners. This judge also ruled, in effect, that female prisoners have no rights. The Democrats on this committee like to say they support the rights of women. But we're about to find out whether they do or not. Because in this case, you're taking a 6'2" man who is a serial rapist, and this judge sent that man to Fort Worth, Texas. I asked that judge, do the women in that prison have any right? If it was your mother, if it was your daughter, if it was your wife, how would you feel if your daughter was housed with a 6'2" man who's a serial rapist? Because political ideology matters more than sanity. And by the way, the threat that this ideologue said is overblown is happening all over the country. For example, in Judge Netburn's home state of New York in 2024, a former prisoner at Rikers Island claimed that she was groped and raped by a male inmate posing as a transgender woman. There had also been a prior rape attempt at Rikers in 2021 by another transgender inmate against a biological female inmate. In New Jersey, in 2022, a transgender inmate impregnated not one but two female inmates. In California, a women's group sued the Department of Corrections after transgender prisoner raped two women, impregnating one of them. And in the chairman's home state of Illinois, a female inmate sued the Department of Corrections after she was raped by a transgender inmate. This is happening over and over and over again, and it's because of ideology being put ahead of common sense. At her hearing, I asked Judge Netburn, do you regret your decision transferring a serial rapist, a biological man, to a woman's prison? Her answer was, quote, no. I faithfully applied the law to the facts. That is not the law, and these are not the facts. As I mentioned at the outset, this committee has received letters from female prisoners horrified at the prospect of being housed with a biological male, fearing quite reasonably for their safety. Interestingly, the chairman has not read to you the letters those female inmates have sent to this committee, pleading on this committee to use some common sense. I'm going to read a couple for you. Alyssa K., a current inmate, here's what she wrote to us, quote, people are already getting raped and nobody cares. Honestly, someone in here is going to end up getting killed. Having men here in prison with us disrupts any sense of rehabilitation. We fear for our safety. We have further loss of privacy as we are forced to share intimate spaces with a man. We watch some prisons are victims of abuse and others willingly engage in sexual acts in our shared space. This isn't right. This isn't fair. Do any of our Democratic members care about Alyssa K's concerns? How about Amy I., a former inmate? Here's what she wrote to us to say, quote, I urge the committee to watch my story and the story of other female prisoners and a brave, resigned lieutenant who spoke out against this anti-woman policy. Women, including incarcerated women, just because a woman is in a prison doesn't mean she loses her rights. That's me talking, not the letter. I'll get back to the letter. Women, including incarcerated women, shouldn't be erased as a matter of law to accommodate the interest of men. One person's rights cannot come at the cost of another's. Here's another letter. Evelyn V., a former inmate, she wrote to us and said, quote, as a former inmate in the California state prison system, I share your concern about how women's rights are being pushed aside compared to the interest of men who are self-identifying as women and gaining entry to facilities meant for women. Now, at the hearing, Judge Netburn told us again she thinks concerns of the risk of Shelby engaging in sexual reoffense are, quote, overblown. I strongly disagree, and as it happens, we now have facts. Just yesterday, exquisite timing, by the way, on this markup, yesterday, the Washington Free Beacon reported that Shelby, who is housed at FMC Carswell in Fort Worth, Texas, was placed in administrative segregation for exposing himself to female prisoners, apparently joking that he was fully intact. Congratulations, Judge Netburn. That's what you're doing to the women in this prison. You're subjecting them to victimization and assault. If a guy on the subway did this, whipping out his genitalia to you on the subway, you'd deck the guy and arrest him for indecent exposure. But this radical says he's got a constitutional right to be there and do this. I have to say, this is an issue everyone on this committee knows this isn't right. Every one of us. Every one of us would be horrified if a loved one found out she was the cellmate of a 6'2" man who was a serial rapist. But in today's topsy-turvy political world, the way you get nominated to be a judge is you demonstrate you're a radical. I know people must be saying, well, gosh, New York has 20 million people. They couldn't find one person qualified to be a judge to give a lifetime appointment to, and that's the point. What they're looking for is show us you're a radical. Well, this is an opportunity for every senator to demonstrate whether you'll stand up for the rights of women or not. I sadly expect a party line vote on this, but I will say this. If we have a party line vote, Mr. Chairman, I'm going to make a request. I'm going to request, Mr. Chairman, that you ask Majority Leader Schumer to expedite a floor vote on this judge on the floor. I want to see Senator Tester vote on whether a 6'2" man should go to a women's prison. I want to see Senator Brown. I want to see every Democrat go on record. Do you give a damn about the women in your state or not? It's a simple choice, and it's a choice that will be defined by the word yes or the word no. I would also ask unanimous consent to enter into the record. These are the letters from women, prisoners, and former prisoners that they're written to this committee. And I would ask, I'd venture to say there's not a Democrat senator on this committee who's read these letters. I'm going to enter them into the record, but I'm also going to ask my colleagues to read these letters and understand the people who this vote is hurting. So I ask unanimous consent to enter these letters in the record.
Without objection.
And finally, I have a letter here from several 9/11 families, including one in Katy, Texas, who sent a letter complaining about how Judge Netburn handled a case involving 9/11 families, the final paragraph of which reads, "We are heartbroken that the court issued no decision on motions by hundreds of 9/11 victims and family members and did not even answer our request for any sort of attention to our unopposed filings. We cannot understand how a magistrate judge would treat 9/11 family members so callously or so blithely disregard her duties, and we wanted to bring it to the committee's attention." So I ask unanimous consent that this letter from 9/11 families also be entered in the record.